Welcome and thank you for joining us today for this business hour. Patent reform, significant changes are coming March 16th, 2013. Is your business ready? I'm Dave Movius, co-chair of McDonald Hopkins Intellectual Property Practice, and with me today is David Kupar, who is also co-chair of the Intellectual Property Practice, and Todd Benny, who is a member of our Intellectual Property Practice. We'll be happy to answer any questions from our audience today during our program. For those of you who are in Cleveland, you can simply write down your questions on the cards that you've been provided and hold it up, and someone from our staff will come and collect it from you and provide it to us. We've got people on both sides of the room. And for our participants outside of Cleveland who are on our national webcast, you're welcome to email your questions by clicking on the email link in the screen, and those will be sent to our staff who will provide us with the questions as well. The American Invents Act, which became law in September 2011, constitutes the most comprehensive change and reform to patent law since the modern patent statute was enacted in 1952. Given its scope, the reforms in the act have been implemented over a series of phases. The first phase, which went into effect immediately, included a number of important reforms, including implementation of a prior commercial use defense, virtual marking provisions, as well as elimination of key TAM false marking suits, and of course, because it's the government, the Patent and Trademark Office, increased fees. You can never let that slip by. The second phase, which went into effect on the first anniversary of enactment last September, in September 2012, included implementation of new inter partes proceedings, the ability to make third-party pre-issuance submissions, and the ability for applications now to be filed in the name of an assignee as opposed to the name of an inventor. Now we're coming up on the 18-month anniversary of the enactment, and which comes on March 16, 2016. And the third and final phase of the reforms are now coming into effect. The one you probably heard the most about is the transition from a first-to-invent patent system to a first-to-file patent system, as well as a new post-grant review procedure and derivation proceedings. So these last three forms, and particularly the change to the first-to-file system, will go a long way towards bringing the United States into line with much of the rest of the world. Now, whether or not that's a good thing, certainly it can be subject to debate, and there's arguments on both sides. But there's one thing we can be certain of, and that's change that's coming. In other words, we all have to beware of the Ides of March. Now, we're talking about patent law here, so the statutory text, the regulations, I mean, they're dense. But don't worry, we're not going to do like some programs go through each section by section, and really dig into that. What we want to do instead is focus on those parts that are going to be important to the IP decision makers in your organization, the people who are making strategy decisions on how to address these changes, what it means for your organization. So we want to more provide an overview of these important changes that are coming exactly 2 months from today, provide you with some practical guidance on what you should be doing between now and those next 2 months, and then how these last wave of reforms are going to affect what your company is doing, what your business is doing from March 16th on forward. So to get us started then, I'll turn it over to Dave here. If you could briefly explain to how our current first-to-invent system works.
Yeah, so just by way of background, where are we now, right? And so we, since the time of Thomas Jefferson being our first patent examiner, have been under a first-to-invent system. So what does that mean? So the first-to-invent system is a system that identifies, based on who was the true first inventor, obtains the patent rights. So theoretically, if you invented first, someone else, a competitor, filed first but invented second, and there was an issue about who owns those patent rights, you would be the prevailing party because you invented first. So in a nutshell, that's what we've been dealing with for literally centuries now under U.S. law.
So it'd be fair to say now that instead of having a race to invent, it's now more of a race to the patent office.
Yeah, that's right. So the idea here is it's not so much about identifying the first inventor, the first company to have inventors who invented, but rather the race to the patent office. It's going to be a focus more now on who's going to be filing first going forward.
Can you explain a little bit why Congress felt this was an important change to enact?
Yeah, so why did this happen? It was actually over a number of years now. The proposed bills hit through a number of Congresses. We're talking about a 6-8 year period to get to the point where we ended up back in September of 11. So what happened was, and the reason behind it, why are we changing, is because of harmonization, essentially. What we want to do is to harmonize our laws consistent with the patent laws that you see around the world. Most of the countries around the world, basically all the countries around the world, follow a first-to-file system. In other words, the first party to file their patent application theoretically would be the party that would have the priority rights to the patent over the second to file, even if they weren't the first to invent.
So is this a significant change?
Yeah, it's a huge change. This is for those of you who follow this, those of you in here who are patent attorneys or involved significantly in the patent process, this is the cornerstone portion of the statute for the American Invents Act that the President signed into law a few years ago now. So this is the key provision.
Now, you'd mentioned harmonization before, and with what other countries around the world are doing. Is this change that now we're having to a first-to-file system, is this the same system that other countries around the world are using?
Yes and no. It's a statute that's been passed. It's going to go into effect with a twist. So just to be clear, it's March 16th, the first date that this new statute will go into effect. That's the effective date. And the difference here is that, based on the rest of the world, most of the world will have a cut and dry first to file system in terms of first to file, the party that files first gets priority regarding the patent rights. Here we technically have what would be commonly referred to as a first inventor to file. We still have inventorship issues here in the United States, which has always been the case, because when you have a first to invent system, you ask the obvious questions that we currently have, which is who invented, when did they invent, what did they invent, and then you look at the other side, maybe a competitor answer the same questions. In a sense, we're not going away at some level from that for some portions of the law. Namely, we still have to identify in our patent applications here in the US, even after the new effective date, who the inventors are. You still have to get oaths and declarations from those inventors. You still have to do those kinds of things that you don't have to in other countries.
Is there any other differences with respect to the notion of a first-to-file system that are important with how this is being put into place?
Yeah, so the big one along the lines of this first inventor to file system is going to be the 1-year grace period provision. So in other words, the thing that the US did to sort of keep the remnants of this first to invent system is this 1-year grace period. Under current law, if you, for example, as a business decide to publicly disclose, offer for sale, publish your invention in any way, it's not a death knell to getting patent rights in the US. What that means is if you do that today, theoretically you would have 1 year from today to file your patent application in the United States. That will basically still be around as the law even after the new effective date of March 15th.
Is there any limitations on who can take advantage of this 1-year period?
Yeah, so the idea behind this is that it's going to be the inventor or anyone that's working in conjunction with or under the direction or control of that. So that's basically more or less how the statute's going to read out, the new statute that takes effect. So in other words, you know, if you're a researcher at a university and you are, as part of your research, publishing, you could theoretically publish after the new effective date. And that publication by you won't affect your patent rights. However, this is the big however, it will affect the patent rights of everybody else literally in the entire world. So if somebody else is competing with you in terms of technology and you publish, that publication will act as prior art right away. It'll actually knock out potentially any patent rights somebody else might have that file for who files after you, except for you. So you theoretically can publish a paper, make an appearance at a trade show, disclose your new product, for example, and you still have 1 year to file your patent application in the US. That's not true in other countries.
Now to bring Todd into the conversation here, can you talk a little bit about what implications, if any, this grace period might have when you're dealing with international protection, international patent rights?
Thanks, Dave. It will have significant impact for international protection. As Dave previously mentioned, a lot of countries, in fact most other countries, have what's called an absolute novelty bar. And basically their laws provide that if there's a public disclosure, an offer for sale, before you filed your patent application, that is considered prior art and will be used against you, and your patent application will not proceed to patent. So it's an important consideration. You know, when you're going through this, determine first, do you want to file internationally? And if you do, you have to think about whether it makes sense to do a publication before filing or whether you need to file before a publication. So it's really going to have some significant impact on international rights.
So is there ways that companies can use this nuance or this window really to their advantage?
You can. You know, if you decide that an international protection is not what you're seeking here for various reasons, you can do a publication before you file, and that publication will be considered prior art against all of your competitors, and it will be considered prior art in almost every country out there. So it's an important consideration. It's much cheaper than filing a patent application, and it's really akin to what we used to have as defensive publication. You can file this or publish this document and preclude others from getting a patent on something that you don't want to get a patent on.
Now the trade-off would be, of course, your foregoing confidentiality that you might have otherwise maintained.
That's correct. I mean, that's all part of the analysis. You want to make sure, when you do the publication, obviously you're putting something out there to the public. And so you have to decide early on, it's sort of a three-prong approach. Do I want a patent? Do I want a trade secret? Or do I just want to publish it? So you have to go through that analysis and determine, based upon the technology, the intellectual property right, and the cost, and how important this invention is to your company or to you personally, and decide which approach is best for you, because there's going to be all kinds of cost considerations as well.
So practically speaking then, how does this change from the first to invent to the first to file system affect what's known as the prior art, or the pool of prior art?
Well, it's going to broaden the pool of prior art. In the past, you had this first to invent really was all about the invention date. Now, what the most important date is your filing date. So in most situations, the filing date is after the invention date. And as such, you've widened the pool of available prior art that can be cited against you when you're prosecuting your patent application.
Can you explain some of the ways then that plays out then through prosecution?
Sure. In the past, in a first to invent system, if you had a prior art reference that was actually published before you filed, but after you invented, you had the opportunity in certain circumstances to what they call swear behind it, which is basically you say, I invented this before this published, so therefore this is not prior art against me. Well, under a first to file system, that completely goes away. There's no more swearing behind a reference. It's all going to be about the filing date of your application. And if there's a piece of prior art that's before your filing date, it could be considered prior art against you.
What other changes are there to the pool of applicable prior art?
So one of the other significant changes with the American Invents Act is that they've actually broadened the definition of prior art in and of itself. It used to be that it was only based, for more or less, it was U.S. prior art that was cited against you. But now they've eliminated the U.S. So international publications can be used and cited against you, where in the past they wouldn't have. International offers for sale. If you had offered your product for sale outside the U.S., that was not considered a prior art event in the U.S., but is now going to be considered a prior art event. So there's important considerations when making sales outside the U.S. It's not the status quo anymore. As of March 16th, that will most likely be prior art against you and could preclude you from getting a patent or really starting the clock on the grace period.
So when we have this broader pool of potential prior art that can be cited against an application, how does that specifically affect the anticipation and obviousness analysis that the Patent and Trademark Office is going to go through and evaluate in an application?
Well, in one respect, it'll make it a little easier for the examiner now, because it's going to be a little bit more cut and dry, because they're going to have a filing date from which to search. They don't need to worry about someone going to swear behind this reference and things like that. It's going to be what it is. But it will create a broader pool, because patent applications publish once a week. New inventions are filed all the time. Publications come out every day, and every day that you've waited to file your patent application, there could be more prior art out there that could be cited against you. So, when you don't have that fallback position of swearing behind anymore, it really is going to be important to get on file as soon as you can. And then the other sort of consideration too is they've redefined a little bit as to what they consider the effective filing date of publications. In the past, it used to be that it had to be the U.S. publication was considered the quote-unquote filing date. But now they've changed it as well, and basically they say, if you had a foreign reference that was published, but it wasn't in the U.S. or filed foreign, that was not published anywhere, but then ultimately gets published in the US as a patent application, a PCT application, and whatnot, they were going to use the earliest priority date, which is a significant difference. It used to be that they would use the US filing date as your priority date, but now it's going to be the original filing date. So that's another consideration that's going to widen that pool, is that you could date back a whole additional year of prior art that could be cited against you in prosecution.
Now, what about with respect to obviousness? There's obviously been a lot of, no pun intended, changes to obviousness analysis from the Supreme Court on down. Is there any specific changes in obviousness that we're going to need to be aware of?
Well, I think as obviousness is one of the key components to it is one skilled in the art at the time. It used to be at the time of the invention. What did they know at the time of the invention? Well, now they've moved that to the time of filing. So if you're in a technology that moves rapidly, the difference between the invention date and the filing date could be 12 months, 18 months. But now you've sort of moved out that time frame of what's considered obvious and what a one skilled in the art would know. I mean, it could be in a technology, 12 months that could really be significant. And what would not have been deemed obvious because your invention date was 12 months prior could now be deemed obvious just in terms of the technology moving so quickly. So once again, the best way to hedge this is to file as soon as you can after an invention date.
Now, we have a question that came in online, and obviously encourage all the questions anybody has. I'll give this one to Dave, and the question is it possible to file a patent application relating to findings that were published 2 years ago?
The short answer is probably not. Obviously, I have to know more facts about that specific situation, but sort of, why do I think that as a knee-jerk answer is, under the current laws, you have a 1-year grace period from the time anything becomes public regarding your information related to your invention. So theoretically, if you published 2 years ago some findings and now you want to seek a patent application for those findings, you would be precluded under the laws. That said, if there's just some specifics about maybe data or something along those lines that was published, but maybe not the underlying methodology, something like that, where you have a situation where the invention itself, the underlying invention, may have been kept as a trade secret, never disclosed, you may have some ability then still to file that application. So you'll want to check more closely what was in the public domain 2 years ago versus what wasn't, and make a determination off of that.
Then another question from our audience here in Cleveland, and that question is, in light of the change in prior art scope, will patentability searches become more important after March 16th?
Yeah, I think so, and I've always said they've always been important. I think they're obviously a cornerstone. Is what's out there. What does the art look like? What does the lay of the land look like in your technology, your art field? And I do think that, and it's also at a couple levels why it's important. I think the broadening of the prior art here, in addition to being sort of theoretical because now it's tighter, I think it's actually real. If you're in a hot technology area where there's a lot of filings, you have a lot of competitors filing in your field, you're going to have a tendency not only just for prior art, but technically what's called 102 prior art. You'll have more shots against you for prior arts from competitors, for example, that read on what you do, or are very close at least to what you do. So if it reads on it and it's even 2 months before your earliest filing date, where in the past you can swear behind it like Todd referenced, you're not going to have that ability now, and you're going to have a big issue potentially from a patentability standpoint. And then like Todd said, even if it's close technology but not exactly where it's an anticipation situation, you have an obviousness issue along those lines too.
And Dave made a good point about the prior art search. So I think the first to file system is going to change the approach to doing patentability searches, because in the past it was, okay, it was invented this date, I don't need to look back prior to that or subsequent to that date. But now, chances are you're doing a patentability search before you filed it. So there's always that opportunity between when you did the patentability search and when you ultimately filed the application that there could be subsequent prior art that was filed or publishes. So it's going to be very important that when you do the patentability search, you try to do it as close as possible to the actual filing of the application. So that way you can really garner all of the scope of the prior art out there and nothing sort of sneaks in on you.
Okay. I want to focus now for a moment on what the time frame, what between now and March 16th, so people can think about it. What applications are going to be affected by this change?
Yeah, you know, based on all the things we've talked about, you know, how do we crystallize it to today? You know, what do we do between now and then? Do we do anything? Is it important to do things? You know, what are they? I'd say the first thing I would say is conceptualize sort of your business and what you do from an R&D, from a patentability standpoint, into essentially two buckets. The first bucket is R&D or developments within your company where you're considering filing patent applications, and then secondly, the other ones are, the second bucket will be pending applications, be it provisionals, utilities, those kinds of things, and I'd separate them out into two buckets.
What about continuations and divisionals?
Yeah. So kind of laying that thought out of the two bucket theory. The second bucket, if you have utility applications pending, if you file, let's say if you get an allowance and you're going to file a continuation application after March 16th, after the effective date, for example, seeking claims on scope that you didn't in the first application, in the parent application, the key to this statute is that it works on the effective or earliest filing date. So continuations and divisionals, theoretically, you won't be affected by them, whether you file theoretically today or after the effective date. If that claim scope you're seeking is based on subject matter that existed in an application before March 16th, you're fine. So continuations and divisionals technically won't fall under that bucket. It's going to be what I call new subject matter that you want to focus in on.
I think this is a very important point, since we have this 2-month window now to address these. And if you can walk through some of the specific options that people have with respect to those different kinds of applications and how that can play out in their strategy.
Yeah, sure. So actually I'll work out even the first bucket, even before you file an application. The first thing you want to look at is what do you have in a company in terms of your R&D right now? And based off of that, how close are you to potentially taking that and preparing a patent application off of it? If you've got subject matter now that you think is going to be a candidate for patentability, and you have enough, for example, data, information, depending on what your technology is, you really should be considering filing that patent application now as opposed to after March 16th. And the reason is you take advantage of today's laws, which you could tell from what Todd was explaining before, are advantageous over what's going to happen, where you're going to have a broadening of the prior arts and potentially more prior art that could affect your patentability rights. Secondly, along the lines of the applications, that second bucket I mentioned, okay, so you have this portfolio, right? You're going to have provisionals potentially in that portfolio, utility applications, those kinds of applications in there. Take a look at those applications and identify, for example, with your research and development team, your engineers, your technical people, are there new developments? Is there new subject matter here as a follow-on that we should add into a patent application? And if so, then you should consider doing it now before March 16th. So for example, if you're converting provisionals to utilities, and your provisional, you're concerned just didn't have a lot of subject matter, you maybe filed quickly before a disclosure happened, you'll want to beef that up. You know, so the next question becomes, should I beef that up before or after March 16th? Same with CIPs. CIPs is short for continuation in part practice. So if you have new subject matter or new development that happened after your filing date, should you include that into what's called a CIP application before or after March 16th? I think if it makes sense and you can do it before March 16th.
What about if you're comfortable that your existing application has all the subject matter that is known to you or that would be appropriate for an application? Is there anything you need to worry about between now and March 16th?
Yeah, I'd still say if you've got a good comfort level, I would still say review with your team, you know, your R&D development team. Are there specifics, even if you're comfortable, it's a pretty robust patent application, I'd still say go back and have the relevant technical people take a look at their own application, or if it's in a certain team, have people look at it to make sure if something needs to be fleshed out, have it triple checked. You're better off doing that, making sure you have some redundancy in place to make sure the disclosures you have, the robustness of those disclosures is there. Because you may think it is, but there might be something that's very important that really wasn't fleshed out. It may end up being new subject matter, and if you file it after March 16th, you're under that first to file system set of rules, which we might not like.
So there are obviously a number of advantages to filing or taking action before March 16th of this year. Are there any advantages, though, or scenarios where you'd want to say, despite those advantages that we might have by acting now, we would actually want to wait until after March 16th to take some sort of action?
Let me start off by saying this is the kind of question only lawyers would sit around and think through, you know. So, and I'll open up to the world here a little bit about my thoughts on this. Sort of, otherwise, these are only thoughts that I have in a closed room. So, you know, are there ways you can take advantage of the new law? The answer, I guess, is potentially, and there's a couple scenarios. The first one's a bit theoretical in nature, but in some industries where you have trade secrets in play, and trade secrets are significant, so think chemical, biotech, at some level, industries like that, you may have a situation where if you know your industry really well, you know your competitors, and you have a feel for the tendency of keeping things a trade secret versus filing patent applications, I could see scenarios where parties might do something pretty wild and pretty exotic, like filing a patent application, the same one actually, on March 15th and then on March 16th. And you might sit there and say, why would you file the same application on those 2 days? You could actually play a game out because you have 18 months before any publication of the application where you have a situation where you can actually play out the field, see what's happening out there. Are there people publishing? Are there people doing things? And if you theoretically have a March 16 application that falls under the new rules, you have a first to file situation. In fact, you have the best situation. You filed first on the first day, theoretically. So there are ways you can kind of play out, especially in new technology, a situation where you can call yourself out as the first to file, take advantage of those rules. I'm not saying you should do this or it's a great idea, but theoretically you could. The one we talked about before, I don't know if it's technically an advantage or not, but if you're into publications or showing things at trade shows in advance of filings, you can take advantage of that too, obviously. Now might be a time you might want to consider publishing because we're segueing into the new laws. You can take advantage of that.
Now, Todd, you formerly worked in-house as in-house patent counsel, and you also now spend a significant amount of your time managing clients' entire patent portfolios. Sort of expanding on what Dave's talked about, what are some of the things that people should be thinking about and doing right now as they're looking forward to this deadline 2 months in front of us?
Well, I think the first step in the process is identification. Identify within your patent portfolio, you know, what provisionals you have outstanding, what PCT applications you haven't converted in the United States, what applications may be potentials for continuation in parts, and then look at what technology your firm or company is developing, and whether that's something that you know it could be a potential to be patented. So it's really about kind of creating a list of all of these elements and trying to figure out, sort of on a case-by-case basis, what system is going to be advantageous to you. I think under most circumstances, you'll find that the pre-March 16th filing is going to be more advantageous, the first to invent system. And making sure that you've, you know, if that is advantageous to you, that you take advantage of it and you file before that date, because otherwise you're going to be stuck with the first to file system. And another thing that we didn't mention, you know, one thing that lawyers love is certainty. And the first to invent system, there's certainty. I mean, there's case law out there that goes back well over 100 years, 200 years. So there's certainty for acts. You know what is prior art, what's not prior art. But the first to file system, it's going to be completely up in the air. You know, we think and theorize that some of the case law is going to carry over, but there's no guarantee that that's going to be the case. I mean, there's a lot of theories out there as to, you know, what is going to be an on-sale bar. You know, is a secret on-sale bar now going to be a complete bar under it, or will it be subject to the grace period? So there's a lot of nuances there that are going to be going into effect with the first to file system. So really take advantage of the certainty of the first to invent, because there's more predictability. And as lawyers, we love predictability. We want to know what the outcome is going to be so that we can advise our clients. And from a business perspective, you know, you've got certainty. You know what it is that you're getting and what you're investing in when you obtain the patent rights. So really, it's about identifying what is potential patentable subject matter that you may seek protection for or look to convert. And then once you've gone through that analysis, just acting on it. Setting up a list of acts you need to do before a particular date. You know, if you've got 35 applications that you need to file before March 16th, it may or may not happen. You may not have the resource. You may not want to dedicate the resources to filing all those before that date. So the next step is prioritizing these things. Put a list and prioritize what it is you what are the most important technologies to you? What's the most important patent applications? Things like that. So much of this is going to be individualized. But the key to, I guess the underlying component here is have a plan, develop that plan, and follow through with that plan.
Now, I want to follow up on, Dave had the good point that there's certain questions that lawyers ask when they're in the room together that are lawyer questions that get lawyer answers. And then there's also things that happen in the real world. And we can talk about this planning and what steps we should be doing. But in the real world, as you're approaching deadlines, it seems like there's always something that comes up right beforehand. So let's say an engineer comes forward and says, a few days or a week before this March 15th deadline, when you're executing this great strategy you put in place and said, I've got this new invention, it's really important, and we need to do something with this. And you've got this very short window now that doesn't fit into that plan. What should you be doing?
Well, once again, this is going to be a quick and dirty analysis you're going to have to conduct. One thing I said, certainty is a good thing, especially from a lawyer's perspective. One thing you can definitely do to try to create certainty for yourself is file a provisional application. Take as much information as you can and just file the application. At least then, you know what you've got under the first to invent system. And then sort of have things play out later. When it comes time to convert, one key component to it is if you want to keep it under the first to invent system, you're going to be subject to whatever you put in that disclosure. So it sort of is what it is at that point. But there may be a strategic consideration to say, we want to convert this to a first to file system. Well, the key to that is going to be adding new matter. Well, if you add new matter to any application that was filed before March 15th, then it's going to ultimately move over to the first to file system. So that way, once again, this strategy isn't going to be a strategy that you do just today or prior to March 15th. It's going to be an ongoing strategy because the same is going to hold true for any application that you filed, maybe a year ago, 2 years ago. When it comes time to file a continuation, should you add new matter? Should you not add new matter? What system is going to be best for you? I mean, really what this is going to come down to is an analysis on almost every application out there as to which system you want to fall into, because you can manipulate it to fall into one of the systems. Now, admittedly, it's going to be much easier to have it fall into the first to file system as opposed to the first to invent, but it's going to be a key consideration. It's not going to be like the past where you just sort of go status quo. Now we've got to do this additional act of this analysis to make sure that we understand which system we're filing in, what rules apply to this, and what are the implications of those new rules.
Dave, this sounds like a lot of work.
It is. So let's break it down. I have a POP theory for this, which is proactivity, organization, and prioritization. That's sort of how I lay it out. What am I thinking about proactivity? I think to be proactive, what you want to do is be proactive in terms of your inventorship team. Talk to your technical people, your engineers, your developers internally, and talk to them about, what are we developing here? Are there things here that are very important to our company, to our business? Are there things we should be filing before March 16th? If so, if there are candidates out of that pool, then you want to identify them and talk through with your business team about, should we be filing on this? Should we be filing on this now? Do we have enough theoretically here? Do we have budgets to support that? Along those lines too, in terms of proactivity and going into organization, for those pending applications you have out there, so you have a docket, you have your list of pending U.S. applications, for your company there. Identify out of those, what are the important ones? What are the R&D folks working on that might be improvements here, new subject matter? Should we add that as new subject matter or file before March 15th? And so this, what it is it does take a village. It takes everybody to get involved to identify those candidates, be it new developments or existing applications, to work through that. It's going to involve business people, your docketing team, your lawyers inside or outside, obviously the technical people to communicate. If you have to set up meetings to do this, to think it through, do it. And it's worth doing it now over the next few weeks as opposed to March 1. It becomes a bit dangerous, as you might imagine, doing it that way. And think about theoretically too, going from organization to prioritization, what are we talking about? We're actually saying in some cases, maybe even a lot of cases, speed up your application process, right? Stuff you would normally do later on, Q2, 3, or 4. We're talking about an effective date that takes place here on March 16th, which is this quarter, right, from a business cycle. you're going to have to potentially get, for example, budget approvals on especially if you have a large scale situation where you're going to be fast tracking conversions quickly here. So get those approvals. You're going to have to talk that through. You're going to have to make a good business case for why that's important for your business. So get those approvals now. Talk through those approvals. Get the buy-in of your business people internally to make sure they give you the budget you need to put this through now. Because the worst thing that could happen is 2, 3, or 4 years from now is someone asking you the question, why didn't we do this before the effective filing date? And you coming up with excuses. So now's the time to be proactive, now's the time to be organized, and now's the time to prioritize those applications. Identify which are the ones we really need to do something about now, which are the ones that aren't as important. Maybe we could push those back and make good business, legal, and technical decisions.
And even though it's a lot of work, the bottom line is your competition's doing this. And if you don't, you're going to be left behind. And I think you can think about these changes as sort of a once-in-a-generation opportunity. I think the last time we really saw changes of this scope or this importance was potentially back in the 1990s when there was the adjustments to the patent terms based off of issuance to filing, and there was significant filing activity at that time because there was the advantages that could be had at that point. I think you should regard these changes similar, if not even more important, that this is sort of a once-in-a-generation opportunity to take advantage of these. And whether or not the changes positively affect you or negatively affect you, you want to be out in front of those changes and making the deliberate decision to maximize that for you. I have a number of questions here too, which is fantastic. I want to go through. Yep, and hit before there's a few other additional points we're going to hit as well, but this is a good time for questions. I'll start out by throwing this one to Dave. Is the question from our audience here in Cleveland is, how does the March 16th deadline affect provisional applications that are filed before March 16th?
Yeah, so how does it affect that? Well, theoretically, if you have a provisional application that you filed, let's just say a few months ago, let's say you filed on December 1, you have until December 1 of this year, 2013, to convert that into a utility. If you don't do it, it's rendered abandoned. If you, for example, have a situation where you need to add subject matter, sort of beef up that provisional, if you will, in terms of the subject matter, if you add new subject matter to that provisional application and you file that provisional application with that new subject matter on or after March 16, you're under the first to file rules. So any of that new subject matter is going to be under a first to file system, not to a first to invent system. And if there becomes an issue of whether or not that new subject matter is patentable subject matter, who invented first, did someone else file first, did someone else invent first, those kinds of things, you're going to be laid at the mercy of the new laws. And also on top of that, you're also going to be laid at the mercy of the laws of the broader prior art theoretically. I'm going to steal one of the questions I saw here, so sorry, Dave.
Sure.
And it goes right into this, which somebody asked also in this audience. The following question is, well, if you filed before March 16th a provisional application, you add new subject matter after the 16th, and you file a utility application with that new subject matter after the 16th, is the examiner really going to take the time to look at it? I have a human nature answer to that. I guess it depends on the examiner. But I can tell you I've had instances in the past where I've had examiners actually take a look at the provisional patent application, call out what was identified or for that matter not identified as opposed to the new utility, and have situations where the examiner will try to find prior art that'll go in between there. So you do have those situations. I mean, to say that doesn't happen, I think, would be wrong. Will it happen practically? I guess it comes down to your examiner, but I wouldn't play with fire there. And on top of it, too, theoretically speaking, it almost doesn't matter what the examiner does, too, because if you're going to play that game out, think of it this way, too. That patent issues and the examiner didn't find a key prior art reference based on something that predates that new subject matter you filed after March 16th, your competitor will. So even if you get a patent issued and you assert it against a competitor, there's nothing to say a competitor won't do that analysis, find some prior art subject matter that predates your earliest filing date, post March 16th, and potentially knocks your patent out.
Sure. Yeah, and just to follow on what Dave said, there is guidance from the PTO. They're setting rules now about the specific process. And the examiner is supposed to identify that there could potentially be new subject matter and actually make a rejection based upon that and give you the opportunity to argue against it. Now, obviously, it's going to be prosecution history that could be used against you, as Dave mentioned, by a savvy litigator. So it's probably better to know that up front before you file the application and make sure that that is the course of action that you want to take.
And so I'll read the question that they were both sort of answering, and so we can get the real sort of fine answer on that, because it is a good question, a very practical question, which was, for applications filed after March 16th that claim priority to a provisional that was filed before, will the examiner be looking at the content of the two to see if there is new matter, and thus whether it should be examined under first to file rather than first to invent? And the answer seems to be yes.
Yes. Supposed to.
Supposed to.
Another question is, another very practical one, is when the statute or the law talks about the filing date of the claimed invention. What exactly does that mean? Because it's a very key phrase.
So the claimed invention is actually a defined term, and it specifically means subject matter defined by a claim in the patent or an application for a patent. So the key consideration here is really going to be the claims of the patent. We talk about the content of the patent. Really what we're talking about here are the claims. And so that's where you get the opportunity to, I guess, manipulate the system a little bit, because you can manipulate your claims to get yourself into a first to file situation if that is what you would choose for an application that has a priority date pre March 16th, 2013. So it's really going to come down to the claims and how you do that. One thing we didn't talk about, I'll mention really quickly here, is that if you decide to go that route, let's say you have a continuation application that you filed 2 years ago, and it just, it issues, or it's about to issue, and you decide to file a continuation after March 16th. Well, for whatever reason, you decide, what? I think I want to make it I want to make it under the first to file system. So you add new matter to it, and it could be as simple as adding a claim that ultimately will get rejected as being new matter, unless you want to claim it as a continuation in part. Even if you take that claim out, the cat's out of the bag there. Once there is new matter, whether you eliminate it and amend it to eliminate it from that application, every subsequent application that claims priority to that one is going to be under the first to file system. So it's an important consideration. There is really no opportunity to correct that. So if you're going to choose to do that, just understand the implications that you're now subject to the first to file, and there's nothing you can do to correct it on the back end.
Be very careful how you draft your claims and continuing applications.
Correct, and that's the biggest consideration is, you may not want to be as aggressive to claim new matter, because if you're going to get that rejection, it could ultimately put yourself in that situation. So, one opportunity to get around that, or one strategy to get around that, is file two continuations. One that for certain doesn't contain new matter, and one where you might want to push the envelope a little bit more. So that way, if your second application, I'll call it the continuation number 2, contains new matter, and you decide that I don't want to be under the first to file system, you can let that one go abandoned, and you'll have this other continuing application that will still be alive under the first to invent system. Obviously, cost is going to be a big consideration when you go this route.
I think you've at least implicitly answered this, but again, another specific question on this point was, can a patent or patent application contain some claims that are applicable to the existing law and some claims that are applicable or analyzed then under the new law, that is sort of having a mixed bag in one application?
Well, the quick answer is yes, it can contain it, but the implications of that is it's going to be considered under the first to file system, not the first to invent. And that is going to include the claims that were under the first to invent system will now basically be converted over to the first to file system. So be careful with that.
Dave, I'll throw this one over to you.
Okay.
Another question is, do the former rules of enablement or enabling disclosure apply in the same way to new disclosures as we've been discussing them?
So enablement, just for the people in the audience might not know what that is, one of the requirements for patentability is, in addition to overcoming the prior art, in other words, having new subject matter that is patentable over what's already known out there, your disclosure as part of your sort of agreement with the government to get patent rights for a period of time, sort of this limited monopoly, is the ability to tell the public how to use your invention. So in other words, if you don't have enough disclosure there so that other people in the art field that you're working on can take what you are disclosing and without undue experimentation reproduce essentially the invention that you created, you've not provided what's called an enabling invention. So in other words, you're not telling the public, you're not, I don't say truthful, that's too strong a word, but you're not being forthright in terms of how to sort of reproduce your invention essentially. So that's a requirement, is the sort of reproducibility aspect of that. And so the question here is basically pertaining to is, under the new laws, what's an enabling disclosure? The things we're talking about, this kind of key period now, this gray zone, if we're adding subject matter, is there an enablement requirement, those kinds of things? The short answer is absolutely yes. That's not been taken away. There's been changes to another area called best mode, that I don't know if we need to get into in the short period of time, but from an enablement standpoint, you still have to have an enabling disclosure as a prerequisite for patentability.
And it's clear that the nature of disclosures, both within an application as far as what's new matter, and also the public disclosures that we've been talking about earlier, are going to be very important. And we could probably do a whole seminar on what the scope of disclosure is needed, or the type of public disclosure is needed to qualify as a prior disclosure under 102.
I'll kind of stop you there because I
Sure.
think that's important. I'll kind of flesh out a fact scenario there, and I think that might be part of where that question's going to. So you have a situation where you go to a trade show, you haven't filed a patent application yet, and you disclose maybe a new product to 500 people in an audience, right? Let's say it's a medical device conference, for example. All right, so the medical device is out there. Now, one question that'll end up either theoretically, let's say down the road in litigation is, and let's say you disclose that a year and a day before your filing date, and you come back and say, well, I was actually okay because the disclosure that was made there wasn't some sort of enabling disclosure. Maybe it was some sort of general statement about a product coming out, but I didn't give specifics about my product, and therefore I wasn't enabling. That's the issue there, is it's still going to be not that dissimilar to what we see, I think, currently under the law. The prior publication, there has to be an enabling disclosure. People forget that. People think just prior art, oh, this product was disclosed. But the underlying disclosure has to identify the components of that product that make it patentable. If it doesn't do that, theoretically, you don't have an enabling disclosure. And it's not prior art, technically. So I think that analysis is still going to apply.
And that's going to be a key consideration, too, is if you're going to do a publication with an eye towards creating prior art, you've got to make sure it's an enabling disclosure. It can't just be a disclosure, because if you do that, and your thought process is, I'm going to do a disclosure, public disclosure, and I'm trying to create prior art for a competitor. If you don't do an enabling disclosure, it's very possible that your competitor could argue, well, that's not a non-enabling disclosure, therefore it's not prior art used against me, and therefore when I filed my application, I basically won, and I'm allowed to proceed, and you are precluded from moving forward.
And that will still, I think, apply to the situations where you're trying to knock out patents, under this first to file. So you have a competitor patent, you have prior art that looks good, it's maybe 3 months, 4 months before the filing date down the road, and you're trying to use that as prior art. At the end of the day, that analysis is still going to apply like it does now, which is that prior art reference enabling? Was that disclosure, an offer for sale, whatever it was, by another party that had nothing to do with that patent owner or their inventors, is that disclosure enabling? So it's going to be still a big issue, and I think at some level it's going to be a consistent analysis. Might be juxtaposed a little bit differently, but the analysis overall is still going to be fundamentally, is it enabling?
It also raises a question, there's a nice segue into another question here of what constitutes a public disclosure in the first place. And there's new language under 102 on that issue that is probably going to need to be fleshed out through litigation and further development of the law as to, is a disclosure amongst private parties as part of a discussion a public disclosure, or does it have to be truly public? Does it have to be on the internet, searchable and accessible to anyone? There's a lot of questions that are out there that I think play into that another question from the audience, which is, as a result of this change to the first to file system, does doing publication searches become as important as searching patent databases for prior art?
I think that's always been the case, to be honest. I think even under the current rules, what constitutes prior art, it does. The new laws don't change per se the subject matter of the prior art. I think it just changes the dates. So in terms of what is prior art at the end of the day, in terms of pure subject matter, that won't really be different. Publications have always been considered prior art. So in terms of your searching, I don't think it's going to change sort of the subject matter of your search or what you're searching. I think it's just going to change ultimately whether this publication that predates your filing dates, does it predate your invention date under a current standard? You can argue over that, but down the road that won't necessarily be the case. So subject matter wise, I don't think it's going to change what you search for. I just think what you find in terms of whether or not it's prior art is going to be the change in the analysis.
One other point might be too, though, is it may also change the jurisdictions in which you do your searches. Now when they switch to basically a system where it's any publication throughout the world, now you might have an opportunity to do some additional searching in other countries, patent offices, to see if there's other publications, patents that may have issued that could be considered prior art, especially when it comes to litigation. When you're spending, no holds barred litigation, people are going to spend all kinds of money to do these additional searches.
We have sort of one final question here that I saved for last because it really ties almost all these points together in a good hypothetical here. And I think we can maybe hit some of these. There's specific questions with it that we can hit and sort of provide the answers here as we move towards a conclusion. So the question is this. It's the example of an inventor who then arranges for a news release on his invention, and it's published in the local newspaper. So we have this public disclosure in a newspaper. Then a month later, another inventor files a patent application on the invention described in the newspaper release. First question is, now we have these two, and then let's say the person who disclosed their application then disclosed the invention, files an application as well. First is, what happens with both patent applications in the Patent and Trademark Office?
Good question. We'll see, I guess, but how it plays out. But I will say something to this question. I'm not sure if it answers it directly, but it's important to think about. We have this first inventor to file, and I think that we can't lose sight of that. It's not so black and white about who files first automatically gets the rights, because of things like publication rights that can knock out someone else's rights to file, even if they technically filed first. There's sort of exceptions to the rule. And one of the things that's going to come out on March 16th, I think that's very important. I think it's going to be still sort of a big remnant that's going to be left of what we currently have. The current system is these derivation proceedings that are going to start. So what's derivation? So derivation is basically, and it kind of goes to this question a little bit depending on how you want to play this hypothetical out. If you hear about or see someone's invention and then derive from that sort of an idea about this invention, and then you file, you technically don't have patent rights. You're theoretically not considered an inventor. You derive those rights from another party who actually invented first. There's actually a statute out there that says that. So theoretically, under this scenario, what could play out, for example, is an unhappy party who maybe did identify their invention first but filed second can sit there and say, hey, the party that filed first, that inventor, you figured out my invention based on that press release, for example. And they could actually file what's called a derivation proceeding under the new rules, assuming this all applies under the new rules, and actually challenge that first to file party to say, they really didn't, even though they filed first, they really didn't invent first. Under this derivation proceeding, they derived their invention from me based on this press release, which, oh, by the way, predates what they did. Maybe it's enabling, maybe it's not. There's going to be all kinds of factors there that you're going to have to look into. I think derivation proceedings are going to be an interesting, hot topic. It's going to develop into its own law that'll be dealing with situations like in that fact pattern.
So it really brings back in that notion of inventorship that distinguishes us from a true first-to-file system.
That's right, and that's why inventorship hasn't gone away. I mean, we still have to file the oaths. It's still an issue of who invented, naming them correctly, because at the end of the day, you're going to have these derivation proceedings, and theoretically, inventorship is going to play under that, because you're going to have to answer, ultimately still, who's the inventor, what did they invent, and when did they invent it, right? So you're still going to have, and this is another thing to keep in mind for those of you who think that, well, under the new rules, because first to file is so important, I don't have to be so robust and force down my inventorship team's strong written records of things. Not true. Think about derivation proceeding. What are you asking there? When did you invent? Do you have evidence showing, contemporaneous evidence showing your invention, those kinds of things? All of those documents still are important. Keep good files. Continue to do what you're doing there. I hate to tell you that, but that's not going to change. So that question sheds good light on that. You have to keep up with keeping good documentation, good records of your inventorship, of your inventions, excuse me.
And of course, in litigation, inventorship will always be an issue as well. So you don't want your teams to become complacent on the inventorship issue, because if it comes time to enforce your patent, you can be guaranteed that your adversary will be looking at that inventorship question and asking you then to produce your invention records, all those documents that have been kept. And if you don't have them, or if you didn't do a proper analysis up front, because you say, well, this is now just first to file, that will come back and bite you.
Put another way, don't include in your company's document retention policy. As soon as this thing's filed, we can throw all this out. I think that's a very bad retention policy.
A couple more quick then specifics off of this this hypothetical is, does the newspaper publication of this press release preclude PCT and foreign filings?
Well, I mean, I'll give you the classic lawyer answer. It will all depend on which jurisdiction you're going to file in foreign. I mean, it's not going to preclude you from a PCT filing, because the PCT basically doesn't do the analysis, because they're going to sort of parse out what laws apply and what laws don't apply. So they sort of just assume that, there is no bar date potential disclosure here and just proceed as that. But, once you get down to the national phase applications, certain countries have absolute bars and other countries don't. The trend actually seems to be a little bit more moving towards granting grace periods. Some countries have actually changed their laws from absolute novelty bars to grace periods. I think Brazil is one example where they've done that, where they're actually coming more in line with the United States. And I think the obvious reason for that is, multinational companies who are complaining that these patent systems are so divergent, they're too hard to manage. So they put a lot of pressure on these countries to make legislative changes to kind of harmonize or attempt to harmonize those rules. So, but Europe is not one that does that. They are an absolute novelty bar. And so, if it's a European application, then it would be a novelty bar, or potentially a novelty bar.
All right, and then one last point that I think we've addressed, but I'll read it anyways. What if the second inventor claims that the newspaper press release was not enabling? And I think that is again going to be a fight, just like we talked about, is the enablement requirement, enabling disclosure is still an element that needs to be proved here. And if it's not enabling, then it's not going to come into play.
Yeah, it's a multi-factor test to answer that.
So one last point then, before we wrap up here, and I'll hit it very quickly, is while this is the most comprehensive reform that we've had to the Patent Act since 1952, it's still a moving target, and that just 2 days ago on January 14th, President Obama signed into law the American Invents Act technical amendments. It has a number of points that are very, they're not as major as the things we've been talking about, but they are important. There's been action to close what's known as the 9-month sort of dead zone that's going to come into play, or would have come into play, where post-grant review and inter-partes review would not have been available. There's changing to the timing of the inventor's oath or declarations, changes to how the advice of counsel defense can come into play that was under one of the prior waves of reform. There's been some changes to the derivation proceeding, where the law now is actually kind of coming in reverse, where the Patent and Trademark Office had interpreted the derivation proceeding statute in one way, but there was acknowledged to be ambiguity there. And now Congress has come around and actually said, we're going to change the law so it's consistent with the PTO interpretation of that. There's been clarifications to appellate jurisdiction for interference proceedings. And then finally, some very technical changes to patent term adjustments that will probably make the adjustments smaller, but it'll apply on a case-by-case basis. And we will be having a client alert coming out on that shortly here. It's being prepared, so you can expect to see that coming out. They'll provide a little more context, and we'd certainly be happy to follow up on any of those issues to the extent they're relevant to anything you're working on. So with that, we promise to get you out of here within an hour. So if you have any questions, certainly if you're in Cleveland, feel free to follow up with us after the program here, and we'd be happy to talk to you about those. For those of you that are on the webcast or viewing this after the fact, you can still certainly email us questions, and we will get back to you. So thank you for joining us today.
Thank you, everyone.
Thank you.
Thank you.